David Crisafulli says there will be further changes to youth justice laws after a 13-year-old boy was charged with attempted murder after he allegedly stabbed a Coles worker at a shopping centre in Ipswich. Well, joining me now is Criminal Justice and Criminology Associate Professor at Bond University, Dr Terry Goldsworthy. Thank you so much for joining us. Now, we've seen the first loophole in the LNP's flagship adult crime, adult time policy, with attempted murder found to not be included on the list of serious offences. Are you surprised it was left out? Do you think it was just an oversight?
Yeah, look, I think it was a terrible oversight, really. I mean, if you look at the list of offences that they put into the bill and ultimately the Act, they're all offences of violence. They carry serious penalties from 14 years to life imprisonment, etc. So attempted murder is an offence, standalone offence by itself. It carries a life imprisonment offence. Why that wouldn't have been included does make me scratch my head. Part of the reason for that may well have been the fact that this legislation was rushed through. I mean, there was a 2-week consultative period, and it was problematic. You rush things through Parliament, you usually make some mistakes on the way through. As has been pointed out today, a number of other offences not in there, such as rape, arson, things like that, other serious offences. So where you take a select group of offences and choose to treat them differently, there will always be a potential for an argument raised that you should have included other offences. So this could be just a issue that keeps on bleeding for the government, and they're continually having to update the list of offences as we go on.
Yeah, and the Premier has said he will make further changes to the youth justice laws, particularly following what has been large community outrage. You've identified some other weaknesses there, some other serious offences left off, such as rape and arson. What other weaknesses have you identified in this policy?
Yeah, look, it's interesting. When you read the explanatory notes to the bill as it was put through Parliament, there are a couple of things that stand out. One is that we haven't got rid of conditional release orders for these offences. So we're talking about the adult time, adult crime part of the policy. There's other good parts such as full criminal histories being shown, access to children's court for serious matters, and the primacy of victims now. But when you look at the adult time, adult crime part of that bill, it's interesting because we can now see that for all of those offences, except for murder, a judge can still issue a conditional release order for a youth offender. So that means, say you got charged, convicted of a serious offence, something like a manslaughter, for instance, and you got sentenced to 11 years, a judge could potentially go, I'm going to give you a conditional release order, in which case you walk out of court without ever spending a day in detention. Now, those orders can apply to any of those offences. And to give you an example of how often they're used, over a 5-year period, we had 1,300 robbery offenders who were youth offenders. 700 got probation, about 180 got detention, and about 150 or so got those conditional release orders. So I think that's a huge gap in the policy where you're saying that these youth offenders will serve adult time. Many of them will serve no time under those orders.
Yeah. The Queensland, as a state, are locking up more kids than anywhere else in Australia. So the consequences, I guess, no matter how severe they threaten to be, they don't seem to be a deterrent.
Yeah, look, I mean, in my time in the 28 years in the police as a senior detective, I saw many people commit offences where they never thought of what the consequence was going to be. Children, youth offenders certainly don't, and many adult offenders don't either. When we look at deterrence, which is one principle of punishment or sentencing, we talk about general deterrence to the wider community, and that's what this is about to some degree, saying that if you committed offences as a youth, this is what will happen to you. For specific deterrence, these youth offenders, when they get this first hit of imprisonment or detention, that will now be a deterrence for them. They will realise that the revolving door, we hope, the revolving door of committing serious offences and getting back out has finished in Queensland. Whether that occurs or not will be the issue with this legislation. I mean, there's another issue in the bill where we've removed the requirement for youth offenders to serve 70% of their sentence. This bill actually amended that and said, well, that's no longer the case. The judges can set whatever limit they want. So I would think judges will set a much lower limit than 70%. It won't be going up, it'll be going down. So we have a problem. We can't house these young offenders. And I think this is a very public backdoor way of ensuring that those limited places aren't overrun by offenders being kept in detention.
Certainly is a complex issue. Dr. Goldsworthy, appreciate your time as always. Thank you.